This next item is SALDO.
Yes. You're up, Andrew. Thank you for your patience.
Thanks, sorry to hold you up, though.
That's the last point I'm making. If somebody at county is working on this, or master, you need to just know. I'm not suggesting it's going to slow us down or change it, but you should know if somebody else is working on something.
Yeah. Well,
Did Sherry mention anything to you about this?
a little bit.
All right.
I'm more interested in DEP.
Pardon?
I'm more interested in what DEP.
Yeah, I agree with that. Okay, thanks.
Okay. So Scott and I met last week, I believe, and we talked about two things: the mobile home section, and then we went over Article 4, which we discussed a couple months earlier this spring. Give some comments, and we redone it and put it together. But the reason we talked about the mobile home section was, you have a mobile home park section in your existing SALDO, and you have, actually, unlike most municipalities, you have an extensive mobile home park section in your zoning ordinance as well. Now, knowing some of the history of mobile home parks in Huntington Township, I suspect I know why it's in both. But the question that Scott and I were talking about last week was, when it comes to the mobile home park standards in the subdivision ordinance, as we found across the county that there's a lot of things that end up in a SALDO that were a remnant of a process many years ago that probably don't fit
Anymore. Yeah.
And your current standards there, and you're not alone in this, just to make that clear. So I'm not singling you guys out, but there's zoning stuff in there, which again should be in the zoning ordinance. We've talked about that in some other sections. But there's also design standards for things like street width, stormwater management, improvement in construction requirements, off-site improvements, sewage disposal, electric distribution systems, fuel supply and storage, fire protection, insect and rodent control, things like that. And the bottom line is several of those things, stormwater, street design, are already covered in the design standards and the improvement in construction standards that we talked about previously. And some of them are a remnant of a generation of prior mobile home park design that the industry's kind of gone away from. And where we ended up was that mobile home parks are the only type of residential development that gets special treatment in the SALDO. And the question on our minds was, is it still needed when we have designs that every other type of residential project survives meeting the existing design plan standards, design standards, and improvement construction standards? That's the first question. I think we settled on that it kind of doesn't make sense to have them called out separately when from a practical perspective, it's really the same thing as a condominium development. Because now, whether you're renting it or buying it, it's still the pad site, the footprint.
The street's still a street, stormwater's still stormwater.
Yeah.
Sewer.
Yeah.
Everything's the same.
I think this is an accident of history because of the
Well, back when there were single
very
wide.
bad outcome.
Yeah,
Yeah.
and you had city water and sewer, you could pack them things within a couple of feet of one another.
Yeah, and we had a special circumstance.
Yeah.
And a lot of these, when the situation that Gus mentions, happened in a lot of places before there was zoning controls
Good point.
to control the density and
Yes.
the pad site,
No,
size, and
Yeah.
everything else.
Yeah.
Now, and again, after 26 years, I should remember, but I don't, is what the timing of the infamous mobile home park proposal was versus the switch over from the county zoning to the township zoning. I don't remember where it fell in there.
99.
We adopted zoning in 99 and that proposal came in 98.
Oh, is that right?
Yeah, they tried to grandfather it in.
Before my time, yeah.
Yeah.
Okay.
And was that outside the area? Is not all the township was under the county zoning ordinance? It was just long, was that?
We adopted zoning in 99. We were
Right.
under the county prior to that.
Right, but the mobile home park proposal was in the area that was outside the county.
Right.
Why is that?
It was only along
Oh,
15.
15,
They had interchange zoning
Oh.
in the county.
I didn't know. Okay.
Every one of our interchanges was supposed to get a motel, and a gas station, and a restaurant. We didn't
Learn
get
something
ours.
new every meeting.
Man, hotel, restaurants, business, the 15 corridor.
Mhm.
We only, I guess ours is in York Springs City. We don't have an exit, do we?
Well, you can't even buy a loaf of bread in York Springs if you don't speak Spanish.
But that's not the point. Let's
No,
stay on the
but
point.
where I'm going is, and back to planning together
Yes.
with the other townships.
I know.
The Route 15 corridor, there's a lot of dollars to capture, and there's a lot of water that needs to be taken care of and designed, where you could have septic and water, where you could actually build viable businesses on that Route 15 corridor and capture some of the dollars and improve the development. Because, just as an FYI to you, I commuted from 1991 to Washington DC for a long time, and this corridor of Route 15 is a huge miss. And the thing is, there's federal and state dollars that nobody ever wanted to touch that are here to grab and make our community better.
So it seems like we've got a decision to make whether to take this out in an area where we all seem to believe it doesn't make sense to be in right now.
Now,
Go ahead.
from, the zoning standards will still be there.
That apply, sure.
And what I'd likely do is, because some of those same standards are also in the mobile home park section in the zoning ordinance.
Yeah,
So again, that would need.
which was thoughtfully done much later than 1998,
Right.
not 2 years ago.
So the dimensional controls would need to be carried over there.
Okay, good point, yeah.
Into the zoning standards that are currently in here, and the ones that are in the zoning ordinance, we need to match those up and see which one, where there's consistency.
Would you
Yeah.
recommend taking one of them out and not having duplicates?
Well, what I think we're recommending is that the standards in the SALDO, that section needs to go.
Go, that salad goes out.
The
Yeah,
SALDO section goes.
Yeah, it's not an appropriate place to put it.
Right, because the standards in there are from that are appropriate to SALDO are already
Yeah.
covered in other sections.
Yes.
okay.
The zoning standards that are in the SALDO, and it's just a few things like, lot size, building setbacks, parking requirements, open space, things like that. That needs to go over here into the
Good.
zoning, but we also need to double check because there's some duplication between your existing SALDO
Well,
standards
yeah,
and what's in
that's where I
the
was
zoning.
going. If you have two different, either they have to match identically or you should get rid of one, right?
Right, well, what we would recommend is we get rid of this one and clean up.
Clean up that.
And
That's-
update that one.
That's what I was gonna say. You can't, if you get rid of that one, you gotta make sure that we can't block out mobile home parks.
No, we're not.
Yeah.
It's gonna be.
And the zoning, what the lot sizes and things will have to be, there'll have to be provision in that somehow in the zoning ordinance to cover lot sizes and things, because they're not the same as.
They're not single wides anymore.
The current, I haven't looked in here, but in your SALDO, it's currently, lots of mobile home parks shall be served by both public water and sewer. Lots should not be less than 50 feet wide,
Yeah,
nor less than 5,500 square feet.
so that you got, that has to be coordinated with the zoning, so.
And that's what you're saying, but what were you just reading from?
That's from your SALDO.
SALDO. Okay.
No, we can't make it that they're not allowed. They have to be
And
allowed.
just for some, to point out part of the issue, your zoning section currently says individual mobile home lots, mobile home park shall contain at least 5,000 square feet of lot area and not less than 50 feet wide.
So that contradicts the,
I mean, you could technically meet both.
yeah,
But it's not that
Yeah.
as bad as it could be, but it's still.
yeah.
So it's really clean. It's cleaning up your zoning
Right.
stuff and saying that, well, this is there. Now there might, I don't know if I think there's some permitting stuff in here that might need to carry over. That might go into a general permitting section in your.
Yeah, in Sal, you were looking at SALDO permit. Okay. Because you keep saying here, and I'm not sure what you're reading.
Yeah, there's a section here, permits and registration and things like that. That can go into the permitting section
Sure.
elsewhere.
Yeah.
Across the whole site.
Yes. Yes.
But the duplication of design standards is probably not necessary.
Okay.
At least in our recommendation.
Well, I would agree. Do we need a motion for that, or you're just working on it, you're cleaning it up, you just do it?
Yeah, this is just an update.
Yeah.
This is work.
Yeah. You agree with that, Mr. Chairman?
Yeah,
Any objections from anybody?
No.
need to clean the make sure the ordinances are.
Take it out of SALDO and clean it up and make it consistent. Whatever was in SALDO that we need to have in zoning or permitting, get it and make it consistent. I think that's what you're suggesting, and that's what we're agreeing to. So the two of you will continue that process. Okay.
Right. We didn't want to come through and give you a
We didn't want,
stuff.
yeah, we didn't want to just assume. We
I
wanted to Give you an
understand,
update.
Yeah,
Well,
So everyone's still in concurrence, we'll keep proceeding.
yes.
yeah.
Those mobile home park ordinances probably date back to about 1972.
Well, we did update some of it when we
Yeah.
redid the
I
code,
mean,
but I'm sure we didn't get everything. in.
But they were initiated back in that time frame and put it in SALDO.
Okay, that's a good one.
When they first started ordinances.
Yeah,
Yeah, and at that time, a lot of things, there's some of the older SALDOs that were placed when I first started. There were a lot of zoning standards that were in SALDO.
Yeah.
As it was a remnant of the time before a lot of municipalities had zoning in the first place.
Yeah, which makes sense.
So it was put to get some
Yeah.
controls were in
Right.
there used to be zoning SALDOs with, setbacks and lot sizes
Right.
and whatnot in them, because that's where those controls were when you didn't have zoning.
Mhm.
It was just applied broadly across the whole township.
Well, there's a whole lot of Pennsylvania law that impinges on mobile home parks in terms of rules for living and leasing,
Right.
everything else.
Quick question, are these gentlemen, do they work for the township or the county?
County.
Or are they the gentlemen that are going to the board? Are they employees of the state, if you will? Or are they citizens, these two gentlemen?
But they're certainly citizens, so yes to that. And Scott is our township engineer, but he's not employed by the township. He is a contractor to the township.
Okay,
And Andy is an employee of the county.
I also happen
He's
to
county
live,
planner.
And you're also what?
I also happen to live in the township.
And you live in the township. And he's a good citizen.
okay. With that said, and it dawned on me, you have a wealth of knowledge with Gus.
Yes.
I think that this township ought to bring in somebody that understands everything to work as an assistant. So back to Pennsylvania law, of which took me a week just to understand my little stuff, to hold this place together. In other words, this past week I found a disconnect between the political side and the nuts and bolts side. And I'm learning here that these two gentlemen, one's contracted, but either way, this township is paying these human beings to go to work for the township. And I think Gus has a wealth of knowledge that he'll have to pass down to some human being that understands state law, rather than we getting all jammed up in some of these meetings and not understand it, because he understands. And there's a wealth of knowledge, and I think we should budget somebody to learn all those things and help him. That's just a thought.
Yeah,
Yeah, it's a good point. That probably should be something to go to the supervisor.
yeah, that's a supervisor's decision.
The planning board has no authority to,
Well, you're planning the township, right?
we make recommendations,
Well, there you go,
that's
recommended.
it.
All right. Oh,
So the next thing I handed out is, it's Article 4, Plan Requirements and Procedures. It says August 2024 version at the top, so you know which one is the most recent one. This represents, we talked about this March or April, sometime. And we had a whole bunch of, Scott and I had talked about it previously, a whole bunch of comments that we've incorporated here. As we sat down to incorporate those comments, we got to talking about the structure being set up before of major versus minor plans, et cetera. And it became clear that the way it was working, that there's some duplication of text in there, and it could be streamlined. And as we sat down to go through it, we were looking at really what's the difference between preliminary plan and final plan, and what goes into what. So what you'll see here, starting on page 6, section 405, where you title the preliminary plan requirements. And we've reoriented this so that you have, I think it's five sets of requirements. There's the details that have to go on the cover sheet of the plan that say what's the plan, what's the basic details about things. Mm-hmm. That covers up until page 8. Then we get onto the existing conditions sheet. It's okay. Here's the existing property. Here's what's on it. Here's what it looks like. Here's what it is before we're doing anything. And then that goes on.
No one else does ordinance this way. This was sort of my radical idea, I guess.
Yeah.
Instead of just having a hodgepodge of all these requirements that bounce around all over the place, let's narrow it down so that these are the requirements that apply to the first page. These are the requirements that apply to the second page. These are the requirements that apply to the third page. Something a little more organized.
yeah, and we badly need this, as we've witnessed with a couple of these plans.
And I'm hoping this has an impact on other townships in the
Okay.
future.
And I can tell you from a review standpoint, if the engineers and surveyors follow through with this and actually follow it, it will make the time you spend reviewing it much simpler, because okay, I'm going through section A, okay, I can have the very first sheet of the plan open, not have to keep paging back and forth through things, especially as I
The
go.
ordinance ends up being the checklist.
Yeah.
Mm-hmm.
Well, is there I just saw this tonight, the revisions, but is there something in there to manage the time? Because one of the issues we've had before was a change to the plan being thrown on the engineer's desk 3 hours before a supervisor's meeting, and the expectation of the developer was, you'll review it and approve it tonight.
Yeah,
And
that was in a previous article.
That'd be
In
more administrative.
the submission.
okay, and that was managed, okay. So this will be the checklist, that previous article will manage the timing, so we're not torturing you and the supervisors, and ended up with, and Gus, and ending up in, I'll stop there, ending up in a bad situation. Okay, Thank you.
Then you go to C becomes the proposed conditions section. And this, it's sort of on page 10, C2. When it came down to it, that was really that was the only of the design requirements. That was the only thing that was added in the final plan. So I said, well, let's just bring it up here. And that way it's up at the beginning. Then D gets into the plan profiles, and then E gets into all of the supplementary reports, the response letter, if they're doing a resubmission, a simple response letter saying how they're responding to the comments. The planning module, their E&S plan, their water supply plan if necessary, stormwater management, et cetera, et cetera. On down to traffic studies, landscaping, lighting plans, traffic control, postal delivery, all of those sort of design requirements there. Then you get into 406 that talks about final plans. And here, the first sentence under there is controlling. This is where we're able to streamline things, basically saying final plans have to include everything in the preliminary plan section plus these things, if applicable. And this gets into.
We ended up pulling out 5 pages of duplicate information, duplicate requirements. That's basically what happened.
It's already covered under the preliminary.
Yeah. There's no why. And I'm all over to restate.
You mean it was
the
covered
same
in
thing.
the preliminary plan? You mean it was covered in the
Yeah.
preliminary
And it
plan?
was simply
It's part of the
regurgitated in final
preliminary
section.
Yeah, so you don't have to restate it. It's already done.
Regurgitating
Yeah.
the information.
So just say what you said. Include the preliminary plan and all this other stuff. Okay.
The one thing we added here on page 13, under 406A3, is it's highlighted there in the last sentence, they're highlighted in yellow. All plans submitted in the context of these permits and/or approvals shall be consistent with the version of the plan under review and/or approved by the board of supervisors. Now,
And that's not the only place it appears.
Okay.
We also had that in this previous statement regarding conservation district.
Well, that's exactly where I was
Well,
going. Because it should be consistent with every plan.
And well,
that's been submitted.
where I was had like the NPDES permits, how many times have we seen them differ from what we saw and what the county sees? I mean, it's crazy.
and I brought this up at the Council of Governments meeting last week, and I'll bring it up here. That because the courts will do what the courts will do. Back in July, I believe, there was the Commonwealth Court, which is the step below the state Supreme Court. It's above the county. If you appeal, you go to county court, you don't like that decision, then you appeal to the Commonwealth Court, you don't like that decision, you appeal to the state Supreme Court. So we're at that level.
Right.
There was a case up that originated up in the Allentown area. It was, if you're familiar with the area, there's 78 and there's Route 33 that runs north and south. Somewhere in there, there's a road, there's a 33 state road, there's another road that comes off of that. And then there's park and ride, and there's I think it's a township road that comes off of that state road that goes back. There's development proposed back there that was not like what people think of warehouses along the interstate, but smaller warehouse look-alike things.
Commercial, yeah.
Right. Big development plan, something like 500,000 square feet across several buildings. The township made the condition of plan that every township does, which is you have to have your PennDOT highway occupancy permit. It's a very standard comment. You've dealt with them, you know that PennDOT takes forever to get their HOPs issued.
Yeah.
This one, from what we can tell, this one in particular was because they needed to get access to the state road, but the traffic came out to it, but it didn't directly access it.
Okay.
That takes, PennDOT holds those up for some reason.
Okay.
In any event, the township said, okay, that's a condition. Developer, for some reason, wanted to waive that condition to sign the plan.
Okay.
So they could record the plan, so they could do something
Move forward.
with the
Yep.
plan.
Okay.
from a planning perspective, I kind of wonder what that gets them, since they can't actually occupy the buildings without access to them, but let's leave that aside. Township refused. Developer said, we'll see you in court.
Okay.
They appealed and won. And the court
Who's
said.
the they in your?
The developer.
Okay, thank you.
Won, and the court said that you cannot hold up plan approval based on since they don't have their HOP in place. You can require them to put a note on the plan that says they have to get it, but you have to approve the plan, you have to issue the building permit, and let them move forward, even though they can't physically get an occupancy permit or do anything else
Oh.
to access it. Now, why does that matter here? Well, if you've ever been through an HOP permit with PennDOT, you know that there's many revisions.
Yeah.
And those revisions can shift an access point or shift the design.
Yeah.
All of a sudden, now you have, let's say the road was here on the plan that you approved. Now all of a sudden, by PennDOT, it's over here. Now all of a sudden you have two different plans. Which one gets approved?
Mhm.
But because of this decision, you can't say, well, we're going to wait until this you have your final permit. No, that's not what the courts have said. Now, whether it stays that way,
Yeah.
whether they appeal, it's townships up there have the money to do that if they so choose. It's a new decision that remains to be seen, but
Yeah.
it's something that's out there.
Yeah.
That is why this sort of thing becomes important, to make sure that you say, okay, make it clear that if the plans are different, it needs to be the same. You need to come back here and revise your plan. This gives you that hammer to say,
Yeah, it does.
we're not, our plan, it's not the same.
Right.
This plan's not valid. You have to come back.
Yeah. Okay.
Well, Scott, when you submit a permit to get a permit from MPDS, or to get that permit, isn't there, and I remember him talking about a consistency report,
Right.
Yeah,
meaning
consistency.
that
to write
the
a
plan
letter.
that you submit to them and the plan that's on file to township are the same, correct?
That's not what the consistency letter says.
It doesn't. What does it say?
It says that the plan as presented is consistent with the guidelines of the stormwater ordinance in the township.
Just the stormwater,
Yes.
not the rest of the plan.
So it isn't that they're identical plans, Jeff. That's part of our problem. This gets us where you're going.
In that letter, that's a checklist item before they'll even look at it to review.
Yeah.
Okay.
So, I mean,
'Cause, not that I was fuzzy on the process, but I hear him talk about consistency
Yeah.
letter, and I was under the assumption that meant both plans were consistent with each other,
no.
only in the stormwater part.
It's only consistent with the concept and the generality of the
Okay.
stormwater ordinance.
Which we could have still argued that plan wasn't, by the way, but it's moved now.
Which is why when I issue those letters, I also have a statement in there saying, just because it is consistent with the ordinance does not
Mean it's,
mean it's been approved for a technical
okay,
review by the
Okay.
township.
okay.
I personally.
I
put those
understand a little bit
letters.
more now, I mean, it's,
It's semantics.
And
Yeah.
games were played, but it can be played. This takes the gamesmanship out
out
of
of
it.
it, yeah,
Good,
as it should.
yes.
Next section on page 14, 407, is brand new. And I'm just like this structure Scott and I put together, this is something that I haven't seen anywhere else. That goes through and identifies required notes that have to be on the plan. And gives them some directions how it should be and that sort of thing. One question that I wanted to ask is on page 15. There's it's the ag notification block. It's currently listed applying to only properties in the ag conservation district. Do you want to keep it that way, or do you want that applied to every plan? There are municipalities that require that note on every plan. regardless of what zoning district it's in. Do you want that notification on?
Because there are ag properties in the commercial zone.
Absolutely.
And they could be next to, you know, a facility or something like that.
Yeah.
You could have, you know.
I think that's a good idea.
Yeah, I
Put
do
that
too.
on there.
I like it, yeah.
Yeah,
What do you think?
I think so.
If they're in, yeah, if they're in production, and if there's, trying to think if there's, like in the residential zones and things like that, there's probably not that many cases where, like up around Iowa.
Well, you got Crestmont up there spraying their trees.
Yeah.
You know,
What's the downside? Just a little extra work, right?
well, it's just sticking the noodle.
Yeah, that's what I mean. by
We don't have a districts that are independent of anything else.
Yeah.
Ours are mixed districts.
Yeah, that's, yeah, which makes this make more sense to me.
I'm just saying that not everything is commercial agricultural surrounding the whole property.
No, you're right.
So, I don't know how
But
that.
again, remember, this note is designed to make future, I think it's doing
Yeah.
a title check, that the right to farm law is applicable.
Right.
And it's to increase awareness of that component, which would theoretically would apply everywhere.
Everywhere.
Yeah.
Mm,
You know, I mean, I'm in a residential zone, but there's, like, believe me, I can smell
there you go.
farm
Yeah.
across the valley.
Yeah.
You know, doesn't bother me, but doesn't bother neighbors, you know.
Yeah.
I think that should be added to everything.
Yeah, I think so.
Man, in planning and in the future, and back to Adams County, there's gonna be a lot of farmers that are going belly up. There's no production in Aspers. They're having a hard time finding buyers. Last year, I rode through all our orchards and the apples are falling off the trees. I met a lady that does apple inspections. You got Asper's going out of business. You got Keurig Dr. Pepper that's sitting on an aquifer, and you have Gettysburg complaining about water. Let's talk about water. You have, and I don't know where our township falls out there, but I do believe it goes up. There is water up right at Asper's, and where we come in, that could supply this whole county. This county supplies Hawaiian Punch for the entire world. And you have Littlestown that doesn't have water. In your plannings, water. I got septic, runoff, all that good stuff. But we have a water supply that's huge. And that's where we have to come in contact with the other folks and understand our geographical piece and understand that the farmers are going out of business unless you want a bunch of solar panels, which is federal dollars coming in, putting pimples all over the place. Whereas the solar panels should be right down 15, and that's a tie-in with PennDOT, and that's the disconnect that the county planners have with PennDOT. All of it has to come together. I didn't mean us and them kind of stuff, but where I'm going is you have politicians saying one thing, you have funds coming in one thing, and we have a disconnect with the employee of the county. Everybody points fingers at everybody else. But in planning, we have to understand that the apple business is leaving town. And that's just me being a witness in the food market industry. In the middle of apple season, you're going to be picking up a Washington apple and the Giant.
It's definitely hurting. Yeah.
Okay, back to this.
Just to the side, it's not the fresh side that's the culprit, it's the processing side. That's what you're seeing, the orchards that are going out or being left fallow. It's usually the processing side that's the issue. That's
Well, yeah, there's a breakdown.
From what we're
Yeah.
told. The other issue with that, and I want to say it was Hamilton Bend Township maybe. They're facing an issue down there of rather large property that simply stopped spraying. next to active orchards.
Yeah,
And
that's a
what-
real problem.
And what happened, and the impact that has on neighboring farms down there. And, you know, they asked, we helped them research it, and there's actually very few parts of the country that have something on board. Idaho, Washington, Oregon, actually find more standards for like New Zealand, Canada, Australia, type thing you do.
Well, you're talking about an organic operation.
No,
No, no.
it's a operation that stops producing, and then they stop spraying,
Well, we had that right up the road here.
and
They
then
drove
it affects
rain.
everything around them. So, yeah.
Did that up to Orler's Corner, I think, this spring.
Yeah, so it's a county, well, it's a national problem, but it's our
Mountain
problem.
View came in.
We have it all over the Park Service.
Mountain Ridge came in and bought a property, or.
What did
That they were producing, that they were
That
producing?
the Park Service has outlawed chemical sprays,
Okay,
and they have noxious weeds that are blowing here and there and everywhere else.
So does the state.
Yeah.
I mean, they don't do anything about it either.
yeah, well, Andy's point is, it's worse in these abandoned orchards.
Oh,
Yeah, I take your point,
Yeah.
Yeah.
but now you abandon, you know, a 500-acre orchard, and it's way worse.
The question becomes who
Who does what?
Who does
Yeah,
something?
because it's not cheap. And the current property owner isn't interested, that's why he abandoned the orchard. Okay.
Let's see here.
Yeah, so did we agree to keep this in for all property? I just want to make sure. You were the only one that seemed to be
I'm
challenged
okay
with
with
that
it.
issue.
I'm okay with it.
All right. Okay.
Let's see, page 21, there's some things highlighted there. This gets into the as-built plans, and so they're requiring that once they're done, the recorded electronic copy has to be submitted to the township so that they have the township has one on file.
Good.
Scott identified the next one there about there's certain outside agency permits require as-built plans. This would require a copy of those as-built plans submitted to the township as well.
How do we enforce that? Isn't that the real issue? To make sure that we get the as-built, because they're done and it's hard to enforce, right?
Oh, yeah,
Who's the enforcer? You?
yeah.
We need a system.
And the other thing is, as-built plans are even written deeds.
Oh, good point, yeah.
I get as-built on commercial properties, I don't on residential. And that's the ones I get all the calls about.
Yeah.
Because that as-built is a good record then of where the utilities, if there's,
Oh, I was, when I moved here and found out you weren't getting as-bills, I was,
if somebody comes in later,
It's just a
years
mystery.
down the road,
Oh,
they
yeah.
want to do something.
oh, yeah.
If you pull out the as-built, oh, well, there's sewer, water, or electric or something, they'll run right through the middle of the property.
Or
The
the
chances-
side of the driveway on the design plan, and they build it on the other side.
Oh, exactly. You're sitting there
Yeah.
saying, I don't know,
Yeah.
this doesn't look like anything that is sitting here in front of me. Anyway,
Right.
okay, good.
The last part that I added, because I didn't know where how to tie it in, was, got to mention something about with stormwater management plans be recorded, or just a copy in the township somewhere. I'm looking for some advice on
Yeah,
there.
the conservation district requires that the stormwater plan is recorded with the O&M agreement.
Yeah.
Okay.
So I didn't know if the township wanted to require that as well, or if it was not a non-issue to you, or just looking for your input on that.
I think if you're gonna have a plan, you should have it recorded, and that thing should be carved in stone. I mean, I've run into places where people have installed a stormwater plan, controls, and then the guy moves into the house and destroys everything you had there.
Well, it should stay there.
It should, but
I'm confused by the first thing that you said. If it's recorded, if it's required to be recorded, why does us requiring it to be recorded add anything to that? Didn't you say it was required? Who required
But
it?
DEP.
Okay, so DEP requires it to be recorded, so then it's recorded.
Right.
And if that's the case, then she's
And-
required to provide a copy.
And. yeah,
Okay, yeah,
And they
I'm with
don't, yeah, they're not required to give the township a copy.
Okay, so it'd be great to have, but your point is you want it to be recorded, it's
absolutely.
required, and maybe that's a double check. That when you don't get the copy, you start to ask questions.
Right.
Did
Well,
something
the
go
only
wrong?
thing that gets recorded nowadays is if there's a maintenance agreement that goes along with it.
Okay, but that's not that common, so,
No.
yeah, okay. So I think we ought to request a copy of the report. Don't you
So
think?
then if you need a copy, you have to get one from the DEP. Well, ain't that a
Well,
joke?
yeah, well, you have to research it at the courthouse.
Yeah, you go to the courthouse, they would never get it from DEP. Yeah, you can
And
forget
it's
it.
a copy of a copy of a copy of something that's this big.
Yeah, exactly.
Shrunk down to this.
Yeah. Find a very
Can't even
helpful
read it.
clerk at the courthouse.
No.
Yeah.
Essentially, we require them
Copy of-
to have two copies and submit.
Yeah.
Record one and submit.
Which is not a big deal for them, but a big deal for us.
Right.
Yeah.
And we'll
Okay.
have, they have the same thing about like the electronic versions of it and things like that.
So a copy, it's already required, my challenge is, the way you're framing the question, required to be recorded or a copy? Well, it's already required to be
Yeah.
recorded, so why don't we just get the copy of the
Right.
report?
And I'm gonna rewrite that,
Okay.
rewrite that to reflect what you talked about here.
Thank
This is more of a placeholder to trigger the
You
discussion.
just copied and pasted my chicken scratch note. That's
Yeah.
why it's,
Okay, well, I don't blame Andy.
it's not perfect English.
I blame you.
That's fine, that's fine.
He'll take the hit.
So, the last thing I wanted to talk about, and we go back to the very first page, gets into plan classifications. We talked about this, but since we revised things, I think it's time to talk about it again.
Okay.
The goal with this section is that anybody that needs to do a plan in the township can come to the section, at least the section, look at it and know what they need to do.
As an example, JVI, they've already said that they're gonna, in the future, they're gonna ask for a waiver from the requirement of a preliminary plan.
Correct.
So that's exactly what we're trying to adjust here. When exactly is the difference, what triggers a preliminary plan versus just a final plan?
Yeah.
That's what we're talking about here.
Now, we talked, and I'm not sure that these are the final ways it should be laid out, but A would be the things that require preliminary and final plans. B would be things that can go directly to the final plan phase. And C are things that do not require a land development plan. So I'll go to B because that's fairly easy. A lot addition, a lot consolidation plan, and that's a fairly easy plan. I can go right to final. A phase plan is an improved preliminary plan. And that's a final plan. Now, maybe that should be up in A that's talking about.
Because it
preliminary.
requires a preliminary.
And final. But then we get into, is there a threshold for number of lots, residential lots proposed that can go right to final plan versus the ones that we do a preliminary and final? Well, what's the threshold on lot coverage? Threshold, like we have the threshold for earth disturbance is if it's over 1 acre earth disturbance, but there's no building coverage, stuff you have to do with land. If it's under an acre, then they don't, and I talked for C about if they're under the stormwater management plan threshold, they don't have to do a land development plan. And we need to confirm what that, the right square footage is.
I know there was discussion in the past, I know, about what constitutes the need for a land development plan.
And that's what part C, that's what I'm trying to clarify that.
Isn't the second, what am I missing? Isn't the second bullet point Okay, never mind, I got it.
There's no building permit.
I was actually comparing the last two bullet points. I'm good. Okay.
So, I mean, from this discussion point, what's the, we need a number in the residential lot section is where we stand at the moment. And it could be something like, if they're requiring, I have one municipality that bases it on whether they have, the residential proposal comes with infrastructure. If it comes with infrastructure, that's fine. If they're stripping 20, they have enough lot frontage to strip 20 lots off the front and get 20 perk sites, then so be it.
No, I don't like that.
I mean, again, that as an example of where we're at here. So
Yeah,
that's kind of where we need to decide what that line
In other
is.
words, you're looking for a number that we'd be comfortable with.
Right.
and typically it's, in the past, we've had a few, there's been instances where there's more lots, but usually it's like a couple. Somebody comes in, splits a lot off to build on, off the parent tract. So that constitutes 2 lots right there, because you got the existing and the new lot.
Right.
So if you had 3, that'd be like cutting 2 new lots off of them.
Well, the things I've run into is if a dad subdivides a lot off her son,
Yeah,
Junior.
the kids are.
Yeah.
A couple months ago, we had a plan where the father was cutting off 3 lots for his 3 daughters.
Yeah.
Yeah,
That's right.
and they're large tracts too.
Right.
So if we take that a step further, say, would have been fine not to have the preliminary and the final?
Yes, you're trying to set a threshold where you can do a final plan, skip the preliminary.
Skip the preliminary, not torture the citizen to just splitting up a lot.
Typically, from my experience, it's been where there's no infrastructure or road improvements, things like that, it's just,
As opposed to number of lots.
yeah.
I think it's hard to get
But how do
this
you,
with number of lots, right?
Well, I'll give you a good example. Remember, you might remember the Lehman subdivision over Old Harrisburg Road. That was done with all non-building lots,
Yeah.
agricultural lots.
10-acre tracts.
Right, 10-acre tracts, and then when I came in here, they converted them all to building
All
lots.
building lots.
So I'm not following your point.
So is that why they're 10-acre lots?
Well,
I agree.
For
They
clean
did.
and green?
or clean and green, and don't forget, clean and green wasn't enforced in the same way as it is today. But if you did a non-building lot, which means it's never gonna be built on, you don't need to do a perk test. So
Okay, yeah.
they did like 10 lots with none of that, and suddenly
Here, but
came in here and
For you, I mean, you have no
and
experience.
to sell them as building lots, converted them, and had them do perks and stuff. And guess what? A couple of those lots didn't.
I have another municipality that sets the threshold. They have there's a sewer system in there.
Okay.
They have a threshold in their sewer regulations for the amount of new lots proposed that trigger a plan.
Right.
So they basically set there for them, if it triggers the sewage requirements, then it triggers land development plan requirements.
If you have a public sewer and you're just doing lateral connections to it, that's a lot different than having to extend the sewer and public water out.
Oh, yeah.
To serve.
I think for them it's 10. It's either 10 or 12.
Yeah.
So it's a significant threshold. But like I said, it doesn't matter to me that is when you need a number. The thing you'll likely deal with is somebody that's, inevitably if you set it 3, 4, 5, somebody's going to come with the next higher number.
I know,
Yeah.
that's the thing.
And be like, now, they can always request
Oh, wait,
a waiver or modification to it, here, and depending on the circumstances, you might decide to recommend grant the supervised
So you have
grant.
6 kids and we have it at 5. It's just as simple as that, give them away.
You can also write it as proposing new lots, which would exclude
It's a good point.
parent track.
Yeah, that's a
What does
good
it
point.
do about your lot size? This township has a lot size, you still hold your lot size within that?
Yes, so all zoning requirements are still.
Yeah.
Yeah, if it's gonna be a house or something,
Yeah.
yeah.
Okay.
Yeah, that also.
You're thinking like five?
I was thinking 5.
Well, I was thinking along the same lines. I mean, do you think there would be that many circumstances that would require more than 5?
It would be very rare,
That's kind of
and
what I
and if
was
they
thinking.
had circumstances, we could give them a waiver.
And, yeah.
I think 5.
Yeah, we need a number, and I
The only question I have left is, should we have another condition? Should there be a condition around public, public utility?
Public, you can put them in what they put them on, a quarter an acre.
Yeah, but see, with what that,
But they have public water and sewer.
I could extend, like, under section A, if I'm proposing more than 5 residential lots and dwelling units, I could add another condition there. Or a plan that's proposing, infrastructure, new infrastructure regardless of number of units.
yeah, see, that's what I'm
And then,
thinking.
and then you
I'd
can
like to see
decide,
that.
then you can decide if they can come in and request and if
Yeah.
it's the circumstances you feel warranted.
I feel happier about the second condition.
Yeah.
That's more important to me than the number.
Well, when I went to York County for a workshop on land development and subdivision, they gave us a plan, a blank plan that we had to lay out, and it was for 100 lots.
Okay,
I've never done a 100-lot subdivision.
No.
The biggest one we had was Flowing Springs, and it was done when I came here. I've never had to do what you might call a major subdivision in this township.
right.
But we run into problems with, for instance, Mr. Fox, when he proposed his 40-lot subdivision, that we're dependent on him applying for water and sewer from the borough.
Yeah,
Well, the borough sets the requirements for that. And one of the things that we learned through the back door is that the elevation of their water tower, which is behind us here, and that subdivision are the same. So you negate the water pressure.
right. So-
That's not in our ordinance. And that didn't come from the municipal authority, that came from the fire department and said,
Okay. But we're answering a different question here. We're answering the question of, do you need a preliminary and a final, or go straight to final? Okay. So I think we've answered that, right? Okay.
I think I've got it.
All right.
More than 5?
More than 5 and the infrastructure. Good.
Since it came up, a little trivia question for do you know why Franklin County does not have a clean and green program?
have a what?
You know
Clean
why
and green.
Franklin County does not have a clean and green program?
No.
No idea.
Because their reassessment base predates the passage of that law.
Well,
I think that law was adopted in the 70s and their last reassessment was done in the 60s.
You gotta be kidding.
So they do not have clean and green because their assessment was done prior to that legislation passing. And as you can imagine from that date on that reassessment, why they don't want to do another one.
Yeah.
So that I was kind of
That's an
surprised when I
interesting
learned
trivia.
that.
Yeah.
I think we've gotten what we need on this section here, and on the mobile home section. Next thing we'll be working on is the revisions we talked about for the Article 5 design standards and Article 6.
revisions for what?
The design, we talked about the design standard section, the improvement construction requirement section. We talked about those in the past couple months.
Okay.
It's putting those edits in like we did here with Article 4. I've started the administration legal provisions sections. There's some things I need to expand and based on the discussion here with mobile home parks, some of that stuff will need to go in there as well. But at this point, I think we've talked about everything. It's just getting the edits made, and then last thing we'll have to do is talk about definitions. But that's the least fine. So that's why that gets up to last.
And that's the most recent thing we worked on, the definition, so it should have the fewest problems. Maybe. Maybe. Thank you,
That's all I
Ian.
got.
Excellent work, and we appreciate it.
This last item is public comments.
You know I'm good. Okay, the agenda didn't appear 24 hours in advance of this meeting, once again. This is the fourth violation of the Sunshine Act in this township since April. At 12:27 p.m. I checked, and the agenda wasn't posted. The next time I checked was at 2:02, it was there. I don't want any excuses.
What day? Today?
Today, yeah. And one of the things is, I want to remind the secretary that is to be noted in the minutes according to the Sunshine Act. Any perceived Sunshine Act violation must be noted that it was brought up at the meeting.
Okay.
I mean, the commissioners learned, because it was in the paper, that one vote, any vote that was taken here or would be taken here, you'd have to wait till next month, because you would have to make sure that we were notified there was going to be a vote.
Now, when you say commissioners, did you mean supervisors?
I'm sorry, the supervisors, yes,
Thank you.
sorry about that, yeah.
Okay.
But they had to come back when they voted that raise and the promotion, because, yeah, it could be rectified, but you have to wait another month. So if you have something that has to be voted on tonight, you would have to wait till next month where it would be properly posted. So, that's it.
Okay, thank you. Gus, what's the problem?
The problem was that I sent the thing in and I had the wrong date on it, and I'm not here on Fridays. And so when Shane,
Who's Shane? I don't know.
Shane's the guy at the county who does our website, he sent a question to me. Of course, I didn't get it till Saturday, and he doesn't work Saturday.
So, could we just move the whole process up a couple of days so that you're not,
Yep.
you had the agenda done, right?
I did.
Okay, so, I don't want to usurp your authority
No,
here.
go ahead.
But we've got to be in compliance here.
I understand.
And so, why don't we move the whole process up? And maybe, Roxy, you and I can bug Gus to make sure you have what you need to get it done.
It was done,
Well,
but it had the wrong
it
date
wasn't
on it.
done if it wasn't
Yeah,
posted.
I
Yeah,
saw that.
so done to me is in compliance with the Sunshine Act.
Mhm.
And you had it done, so it's even worse, because if all the work was done, you're not sitting there saying, I didn't get my work done. You got the work done.
Mhm.
Okay, I agree, you had the wrong date, you have to rectify that. So,
I think it'll be easier when we are in charge of our own website.
okay, but we have enough information and enough structure in place to be in compliance now.
Yeah.
So, I wasn't aware of some of what was happening. Let's make sure it doesn't happen again. It's not the turn of the century, but let's make sure.
Yeah, and if it's ready, I don't understand why. Okay, even Pat, you never see, I mean, I'm sure when she leaves here at 5 o'clock, she's handled everything, and the attorney reviews the supervisor's agenda, and like he had a Sunshine Act violation because he did not put down on the agenda that they were going to.
Can I just ask not to use pronouns? Who's the he?
I'm sorry, the solicitor,
Okay.
okay? The solicitor reviews the agenda for Pat. And the thing is, he had, what was the first one? About the unconstitutional resolution. And they also had about the zoning. Well, they didn't put that they were voting on that. So that's a Sunshine Act violation, because no one looking at that agenda knew that a vote was going to be taken. And that means comments. I know a lot of people do not come to these meetings, but it is a serious issue. And as a commission that expects the residents and businesses to comply with all these rules, I just find it horrendous that an agenda can't be put on a website, no matter whose fault it is. But thank you, I appreciate it.
Thank you.
For clarification, I guess, like the planning board, we make recommendations to the supervisors.
Yes.
If we make that recommendation, we have to do that, plan for that a month ahead, or can we do it? A lot of times it's pretty spontaneous in what we do. You know, plan comes in here, if it's ready, and we'll move it along. Then it goes to their
Then it's
agenda.
on
I'm pointing to the
Then it's on
supervisor.
their agenda, yeah.
It goes to their agenda.
Yeah.
So my answer to your question would be, if we know we're gonna vote on something, it should be on the agenda. Sometimes, to your point, we don't know. We get new information and we make a decision at the time. And because we're not creating regulation, they are, they being the supervisors. We have some flexibility in our voting.
That's,
So,
I think that's your
okay,
point.
so you're saying that,
Who's
If
you
we're-
here, me?
huh?
Is the you me?
Yeah.
Okay, go ahead.
So Tom, if you're
Yeah.
saying that, I mean, are you saying that we can't make any motions unless we have in the minutes that we might make a
That's
motion?
not at all what I'm saying.
Okay, what are you
To be
saying?
clear, I'm
Yeah,
saying if
please.
we know we're voting on something,
But our voting is a motion.
I know that.
Okay.
If we know that we're voting on something, we should note it on the agenda. Sometimes we don't know. And because we're not making law, we're making recommendations to those that make law, we have more flexibility. In other words, we could have a situation where we don't vote on it because circumstances have changed and we don't have enough information. We table it, or we move on, yeah. And secondly, the other condition is the reverse of that, where something may get in front of us that we didn't know we were going to vote on, but we can vote on it because we're making a recommendation. We're not making law. Okay?
Supervisors gotta worry they can't vote on anything that spends money unless it's on the agenda. They don't have that burden.
does that sound in compliance?
Well, the thing is, I'm shocked because Todd King, the solicitor, doesn't seem to be familiar with the Sunshine Act. I mean, I'm amazed. Like I said, he reviews, because I get copies of his bills under right to know request. He reviews all the agendas, back and forth, I guess, and I don't understand why he does not realize that when you're, especially the supervisors,
Yeah.
and it's something the township solicitor should be advising on. Did I say the township solicitor should advise you guys on it because
Well,
of the fact?
I mean, he's our solicitor too.
Yeah.
But we're in a different position than the supervisors.
Correct, yeah. But you're still under the Sunshine Act.
I understand.
You know, no, I realize that. So I appreciate you at least discussing this because it would be an issue for you. As I said, if you vote on something here, you'd have to wait till next month, just like the supervisors had to.
Yeah.
And it could create a serious issue, so. You know, we all have to abide by rules and well, not rules, but the law under the statute.
And
So.
you're talking about easy things for us to comply with. I mean,
Yeah.
like I said,
Yeah,
it's not the hardest thing to do. It's also not the crime of the century, but there's no reason why we can't be in compliance with that
yeah,
pursuant to what
yeah.
is laid
But
out.
thank you. I appreciate your discussing it and hopefully handling it.
Any other public comments?
It's more of a question.
Yeah.
Back to my civics thing and agendas, I call them councilmen, but whatever they are down there in the county, they did not have an agenda. And I questioned Lee on it, Lee, whatever his name is, the big guy. And he's like, yes, there was. And I was like, no, there wasn't, but they gave me time. But more importantly, I realized that how, not this room, but the supervisors, when they make law, this township, there's nothing in the state that can be done unless this township is involved. I went to the county and they told me everybody, I had to come down here. It was just like blowing hot air up there. And the vitalness of this place. Now, with that said, when it comes to enforcement, the county's going to talk about sheriffs and they're going to talk about parole boards and they're going to forget about prisoners. But when it comes to execution and somebody reaching up for the money, will this township collectively gather with all the other townships to make our county come together?
Oh,
So we do work with other townships,
we tried.
yes, but they have to cooperate with us too, Jamie. It's not, that has to
I'm
go
just trying
both
to tell you,
ways.
that's how important it is.
It is important, and we recognize the importance.
I recognize how important to my little poisoning issue that this township is. There was no one in the state, no one, except this little group of folks. And now I learned that, and it was a hard lesson. I'm not much of a government kind of guy, but I learned in the state of Pennsylvania, all law comes out of this room.
It's the concept of subsidiarity, and we follow it, and that's what you're living with, right?
Right, but what I'm saying is you have big politicians way up here, and they're tossing around money. And I want to know how, from the ground here, this is my question, how does this room acquire some politician shouting he's got $2 billion? We're playing in the county, you're planning roads, you want to build a bridge, you want to build a historical bridge. How do you get the money to build a nice historical bridge to replace, the perfect example is Wireman's Mill Road. There was a lovely bridge down there in this county, it was a PennDOT piece.
You said it right, PennDOT had.
But but back to working with PennDOT, how could you say you're not going to destroy this neighborhood and put a big concrete thing over the creek when we want to have architecture of Apple Country and promote this place? How do we do that?
Andy would like to respond to your question. Go ahead,
I
Andy.
can tell you how that one in particular happened. It happened because the county owns the sister bridge to that one down in, over between Mount Pleasant and Oxford Township. I forget what exactly road it is. And there was a design